Hi and welcome. In one moment, we're going to share some presentation slides, but we just wanted to say hi to everyone. Thank you for joining. Okay, here we go. So first of all, we'll just welcome, and you're at the right place if you intended to be at the Franczek Title IX Team Meetup. We have these scheduled for the first Tuesday of every month from 12:30 to 1. We always try to give timely information, what's going on with Title IX, especially since the new regulations, what's going on with the new regulations, what do administrators need to know? So that's what we're doing here today.
Great, and for those of you who are new to our team meetings, first of all, I'm Amy Dickerson from our firm. I'm here with Jennifer Smith and Kendra Yak. And this summer, we decided to offer a place for Title IX administrators and practitioners to meet and raise and discuss questions in the field as they work to implement the new Title IX regulations. So we now meet monthly on the first Tuesday of each month from 12:30 to 1 p.m. And we've heard from many of you this summer that you wish that the meetings could be recorded. So we have switched to a webinar format so that we can record and then share these meetings. So you can still ask questions using the Q&A function, and you can even ask those questions anonymously if you prefer. So we hope that this will help strike the right balance of offering a safe place to ask questions with the need to make this programming accessible to all of you after just the time that we air it live in light of your busy schedule. So make sure to sign up for our alerts at franczek.com/subscribe so that you receive notices of these team meetings going forward, as well as a list of all of our other thought leadership and insights. And please also make sure to check out the many materials we have posted on our blog, which if you don't know, it is title9insights.com.
Okay.
Yep, go ahead, Kendra.
Today's session is an Ask Anything, so please do let us know if you have questions. You can send your questions each month to events@franczek.com. And do save the date for our next team meetup, which is February 2nd, 2020. And throughout today, like Amy mentioned, put your questions in the Q&A, and we will try to answer those throughout our session.
And for those of you who do receive our alerts, know that in early December, after our last team up meeting, we issued an exciting new resource for Title IX coordinators and other team members. And it's our Title IX decision tree, which was formerly called the Title IX Sexual Harassment Intake and Grievance process.
And so this was just in response to feedback that we got, which was, even after the training, when I actually get a complaint in the door, it's very overwhelming, I think, the new regulations, which definitely we acknowledge. And, we would not necessarily have designed them. That we have to live with what the law is when it is. So we know it's very complicated, and there's a lot of steps to take. So the decision tree, the goal was to really walk you through, even if the training's not fresh in your mind, what do I do? What do I do next? What do I do next? And just to avoid any missteps in your investigation process. So that is available.
All right, so for those of you who do follow our blog, you may have heard about a recent decision by the U.S. Supreme Court not to review a case, which has led to the question, what is this decision and what does that mean? So in early December, the U.S. Supreme Court declined to review a decision allowing transgender high school students to use bathrooms and locker rooms consistent with their gender identities. The high court's rebuff means that the lower court decision stands. So this is a tacit endorsement that solidifies an understanding of Title IX supported by other courts, including the only other federal appellate court to address the question. The decision is also notable because of the new composition of the court, with the addition of Justice Amy Coney Barrett. The case offered the court an opportunity to quickly narrow the holding of the recent transgender employment decision, Bostock versus Clayton County, yet it decided not to do so.
So in Parents for Privacy versus Barr, the petitioners were a group of parents, Parents for Privacy, and the group challenged an Oregon school district's policy allowing a transgender male student to use boys' facilities at his high school. A trial court dismissed the case, finding that it did not state any valid claims, and the Ninth Circuit Court of Appeals upheld the dismissal. The parent group then asked the Supreme Court to review the case.
So in their request to the Supreme Court, Parents for Privacy raised numerous arguments about the school policy. They said the policy interfered with their rights to direct their children's upbringing, infringed on their rights and their children's rights to have free exercise of religion, and violated their children's right to bodily privacy. Finally, they claimed that the policy created a hostile educational environment and discriminated based on sex under Title IX. Here's the crux of the Title IX harassment claim. So the parents are arguing that requiring the children to expose their bodies or to be exposed to the bodies of individuals assigned a different sex at birth creates a hostile environment based on sex. Justice Alito raised a similar concern in his dissent in Bostock. He said, "It is a matter of concern to many people who are reticent about disrobing or using toilet facilities in the presence of individuals whom they regard as members of the opposite sex," and warned that Title IX might be implicated in such a case. In this case, Parents for Privacy asked the court to provide guidance to schools on the critical issue of whether designating facilities based on gender identity instead of sex assigned at birth is permissible under Bostock. So the Supreme Court does not typically explain why it declines to hear cases. The school district's brief in opposition to the petition provides some insights, though. So according to the school district, no cisgender students ever saw the transgender student undressing or using the bathroom or locker room, or vice versa. So there's sort of a factual question here that maybe made it less interesting for the court to look at and make a decision about. Additionally, the parent group raised several arguments for the first time in its petition to the court, which is not allowed under court rules.
So I thought it might be helpful if the name Parents for Privacy are familiar to people who are watching or listening. Yes, it's a very similar legal action to what we saw here in Illinois against School District 211 a few years ago. That was also a parents group who called themselves Parents for Privacy, sued the school district. I believe it's the same. I believe Alliance Defending Freedom is the nonprofit attorney group that was involved in both cases. And so very, very similar arguments. There are some differences in and there's differences not just in these, but overall in a strategy that one might see, and things that are maybe reasons for courts to punt, but why we can't extrapolate too far. So like you said, Kendra, these cases are light on facts. These attorneys are seeking to make legal points, and I would say that my perception is the plaintiffs are not too interested in a full discovery of a fact situation. So they try to keep it at the policy level. So the challenge was that the policy of allowing any transgender students in the locker room violated the law, regardless of what actually happened, if it was actually causing a problem for anyone. And so it's on that level that we're still getting these cases, as opposed to a cisgender student, I mean, just to be blunt, seeing someone with a different biological sex physique naked in the locker room. Those were not the facts. Though that's always the kind of scare or fear that's underlying, the threats, but that's not what happened in this case. So that's not the basis of the decision. We have it on a very policy level. Can a district have a policy that allows transgender students to access these spaces, not about what actually happens in those spaces?
So then I think to even Jennifer's point, it's unclear whether the Supreme Court would reach a different decision if facing evidence of exposure between cisgender and transgender students, to which the cisgender students objected. So this case is yet another piece in the often confusing puzzle facing schools when it comes to transgender student rights under Title IX. And the U.S. Department of Education Office for Civil Rights, as many of you know, rescinded Obama-era guidance allowing transgender students to use bathrooms associated with their gender identity. And OCR consistently has denied that Title IX applies to transgender students regarding facility access under the Trump administration. So with the incoming Biden administration, we do expect that the Department of Education's guidance will realign with the trends in the courts, including those recognized in this situation. So it is more important than ever to consult with legal counsel on any issues addressing transgender rights in schools. And we will continue to monitor the case law and news of the presidential transition to keep you updated as the issue develops. And of course, if you have any questions, please contact any member of our Franczek Title IX team.
Yes, and I guess I just want to reemphasize for those in Illinois, this is not a change. So we have a Seventh Circuit decision that is pretty clear that there's legal liability risk in the courts if you do not afford facility access to transgender students. So I think first, and I guess this case, if anything, you could just take it as reaffirmation that a district could have a policy allowing transgender, it's the flip side. So in the Seventh Circuit, our case said, you know, it violated the transgender students' rights to not have access. And this case says the school district does not violate cisgender students' rights by having a policy to allow that transgender student access. So two sides of a similar coin. But regardless, we were kind of already there in our area, not to mention we have, if you're in Illinois, the state Illinois Human Rights Act that has been interpreted as giving rights to students, transgender students, to facility access. So for most of you, is this a change? No. Do we now, if there's more guidance, like Amy said, I think it's an interesting thought, you know, what do we expect from the Biden administration? I do not have any back channels or ways of knowing how they might handle it, if it might be the same as the guidance that we had under Obama, or it could be different. I really don't know. They obviously have a lot on their plates on day one as far as education with everything COVID. So it's also kind of interesting how COVID's impacted some of these issues. You know, a lot of the issues that I think districts had gotten past in a way, the facility issue, but a big issue out there is how do you deal with parents and information sharing with parents about gender identity at school. You know, as the walls between school and home have just deteriorated, I think those are even more challenging and interesting questions in some sense now that I think before there was, you know, maybe a thought that a student could have a separate identity at school that is not necessarily known to parents. That I wonder how those situations are going as far as being really challenging with all the homeschool integration we have right now. So anyways, there's a lot of different directions one could see this going, but interesting new case. And I don't think it's the last word from the Supreme Court either. Just because they passed this case, I mean, this case had a lot of problems with it. I don't think it was the perfect case that one might want to take up if they want, you know, if the Supreme Court wanted to speak on this issue. This, you know, did not have well-developed facts. It's a little murky what the issue concern was because of the way the facts were. So anyways, I wouldn't read too much into what our new Supreme Court with the conservative justices might do with one of these issues someday. So moving on back to thinking about your role as a Title IX administrator in the present, we have districts, you know, one, reinforce that the new Title IX regs, even with the change in administration, they are still the law. They are still what one needs to follow right now. And So we have been getting questions, what if you're not trained or you don't have individuals at your district trained in the various roles? Our colleague Jackie Wernst is definitely out there sharing information, and follow her on Twitter for this kind of information. You can see her Twitter name there, but what to do. We do have training solutions. So what if you're not trained and you get a complaint? Either, we have training solutions to get you trained quickly, or there are ways that you can outsource certain roles to people who have been trained, whether it's attorneys or other outside vendors, because you need trained individuals in the specific roles that the new regs require. So whether it's doing training or hiring someone just for that discrete role, there are solutions if you're not trained.
The other reminder that we wanted to provide is that there are certain things that need to be posted on your website, and hopefully if you're listening to this, you are already very engaged in Title IX and the new regulations, and so you are on top of all of these things. But just as a reminder, you need to have all of your training materials used to train your Title IX team posted on your website. So all the training for your Title IX coordinator, investigators, decision makers, and anyone who facilitates informal resolution, that needs to be publicly available on the website. Additionally, you need to have the Title IX coordinator information, including the person's name, title, office address, email address, and phone number, so that is accessible for anyone to be able to identify. And finally, 3, you need your policy language. So you must post a copy of your non-discrimination statement on your website. And the non-discrimination statement must include a number of specific things that should also be in your board policy. So if you're a school district and your board has not yet adopted a new sexual harassment grievance procedure, you should post a provisional procedure on your website. So this is sort of in process, but this is how we're going to be operating, and your board should be reviewing that at this point.
I think this is one area that we've been monitoring and where we've seen an uptick in compliance issues, where it's been long enough since the new Title IX regs out. The first thing when there's an issue that, a regulator is going to look at is, okay, they're going to pull up your website and look for these things. So this is definitely one of the top to-dos if you don't have this information yet.
And if you find yourself not having this information and want to get some help with getting it quickly up, we do have a template that we've prepared for a number of other clients and schools to have the information that you need posted on your website. So please don't hesitate to contact us and we can get you more information, about that. We've also worked with schools to kind of figure out the best way to even where to place this. That's sort of a logistical question, but whether it's something that it has its own page or do you put it with your HR page? And so, we're happy to talk through those things with you as well. But the key is to get it up there and then to continue to post your training materials on that page as you continue to get trained.
And I see we've got one question. We've mentioned we have a number of resources available to you. One is our Title IX toolkit. And recently an update went out for that. If you've purchased the toolkit, as we update it, you will get those included. And so the question was sort of what are the main takeaways from that update? And Jackie is our fearless leader on our toolkit. And unfortunately, she's not here, but she was able to give me a couple highlights. You have some additional language to choose for in various places. There are updates to the advisor notice form, more options for limitations for advisors. And these are all free if you have previously purchased the toolkit, and they come redlined. So you'll be able to identify sort of what's new that you may want to be changing within your own documents, and then what remains the same.
Great. Well, I'm going to take it off share, ladies. Is there anything else? We'll give it a minute and wait and see if anyone else has any more questions. Otherwise, Amy or Kendra, have you, I know I have had some major Title IX complaints this fall, even being remote, still in one big one, a historical complaint going back maybe 15 years. And so those kind of, we had a flood of more like Me Too, you know, during the Me Too rise and everything of older former student complaints, and still seeing that with some districts as different communities, especially as different communities form, maybe Facebook groups, you know, a survivor group, and then others chime in and share their stories. So you do have obligations with those.
Yeah, and I've seen a number, especially now that we are, for the most part, you know, a lot of things are happening not at school. And so instances, events will come to the administrator's attention that, you know, happened off campus, happened not part of the school day. And we really are focused on that initial analysis of, is this something that falls under Title IX, or is this something that's outside? And in a lot of cases, it is not going to be a Title IX. You're going to go through your you know, bullying or code of conduct process instead of the Title IX process. But it really has made us focus on those criteria of when is it going to be something we're going to address through our Title IX sexual harassment process.
I'm seeing a lot of those same questions as well, Kendra. And I think when there is a gray area, or where we find ourselves with sort of the limited information that a school might have initially, and it seems like, you know, it probably is not Title IX, but potentially it could be. I think, you know, I think that's where, you know, often I'm seeing districts still taking that first step, if they can, if they have even information to do so, to at least reach out and do that meeting with the alleged victim to let them know about the procedures, available resources, and perhaps even then to do some intake and get some information more that they might need, as a way to at least, you know, take that step if it was needed to kind of take a conservative approach. But then also really being mindful of the fact that it's possible we're still kind of assessing, you know, which policy are you ultimately going to end up applying, which is a new sort of way to look at these issues that we haven't always looked at. It's something that that's always been present with all these different policies, but now under these new Title IX regulations, it's a lot more important to really make that assessment. So I'm seeing that as a big question. And I think a question probably especially that we're getting as attorneys, because those are the types of questions that I think can be very helpful to be really talking through with legal counsel about.
Yeah, and I had one situation come up which kind of changed my thinking a little bit about that decision about whether it's Title IX or not Title IX, and the need to make it clear to the respondent. So if you decide it's not Title IX and you're not following the Title IX process, making that clear, because I think now if you're a respondent or, you know, not an attorney, just a student's parent, and your child's been accused of sexual misconduct in some way, but let's say it's in that off-campus, you know, non-Title IX because it's not in your jurisdiction. But I think sometimes now they're going to look online and think all those Title IX processes apply to their child. And so I'm seeing some confusion and some demand from, you know, respondents in what you're using is really a code of conduct process. I don't think legally it's a problem, but logistically and communication wise, it is a problem, because they're like, well, I have a right to this. And it's like, no, you don't. But it's very confusing. I mean, I see why people are confused, certainly.
I think that's a great point, Jennifer. And I think oftentimes when we think about making it clear that we're not going to be following a certain policy, we often think about making that clear to the complainant. But for all the reasons that you've just described, I think that's also a really important point to make that clear to the respondent as well, that we've made this determination that, you know, for this reason, it doesn't apply here. And then also keeping in mind that if as all of you know through our trainings, if you were making a determination that the Title IX policy doesn't apply after a formal complaint is filed, then you actually have to follow the formal dismissal process and give the right to appeal that decision. But I think what we're all kind of talking about is even, you know, prior to any formal complaint filing, you know, what policy are we following from the get-go?
Right. Yeah. No, I was definitely in the no formal complaint. You know, complainant doesn't want to file a formal complaint, but respondent actually wants the procedural protections of the they almost want a complaint filed, you know, they want that process. So that's kind of interesting. I hadn't necessarily thought about that when we were just, you know, looking at it without any facts before us. You know, these things do evolve as you get some experience with new laws. So well, I don't know, we did get one more question to repeat the documents in the toolkit. I don't know if Kendra, what were those main things that you hit on?
I think the main things had to do with the advisors, as well as a couple different, some language for different options, and I'm not sure which section that applied to, but it should be in a red line in your updated toolkit. And Jackie Werns will be able to give you additional details. I can have her reach out to you guys.
Thank you.
Well, and I know we also put out a recent, podcast where we talked a little bit about what we might anticipate under a Biden administration with Title IX. As Jennifer said, the crux of what we come up with is that we don't have a crystal ball, but we did talk a little bit more in detail there. So if you haven't gotten a chance to take a look at that or listen to that, feel free to do so. But then we do anticipate that we may have even more actual information that we may be able to discuss at our meeting next month about, what we're now seeing out of the new administration once we see the new administration take over.
Yeah, that was really, you guys did a deep dive, and I think Jackie did a deep dive into what are the options if the new administration wants to do away with the Title IX regs. And just from a person who's interested in law and in politics, it was I thought it was fascinating. What are their options? And what you say, I mean, it makes a difference that the Trump administration went through that regulatory process and actually formally adopted new regulations. I mean, that is legally very significant. Although, Jackie did explain it's not that there is nothing they can do. There's obviously things they can do, but there's no magic wand. It will take some time.
It's gonna take time, yeah, for sure. It's a big process.
Well, great. If we have no other questions today, we just want to remind everyone, join us again that first Tuesday in February. And thanks for joining us today. And we will post online if you want to share with any of our colleagues. Thank you.
Thanks.
Thanks, bye.